So, you've got these incredibly powerful AI models, the kind that could literally reshape entire industries, maybe even our society. How on earth do you regulate something like that? Well, the European Union thinks it has an answer, and they've just rolled out a whole new playbook. We're going to break down exactly how it works.
And really, that's the fundamental question at the heart of the new EU AI Act. This isn't like regulating a new smartphone. We're talking about creating a legal framework for a technology with power and reach like we've never seen before. And the EU's entire approach hinges on one brand new and absolutely crucial concept.
And that concept is systemic risk. Now, let's be clear, we're not talking about your favorite app glitching out. This is a whole other level. Recital 110 of the Act, which is basically an explanatory note setting the context, defines this as the potential for widespread harm, the kind of harm that could affect our critical infrastructure, our democratic processes, or even our fundamental rights. It's a completely new category of risk, and you can bet it requires a completely new regulatory process. All right, so to really get our heads around this, here's our map for today. We'll start with what systemic risk really means for AI. Then we'll look at what kicks the whole regulatory process off. We'll dive into the back and forth between companies and regulators, see who makes the final decision, find out what happens when a model gets on the list, and finally talk about that tricky balance between innovation and precaution.
So, first up, AI and systemic risk. This isn't just some new compliance checklist. The EU has actually built a special legal pathway just to handle the biggest and most powerful AI models out there.
The heart of this whole thing is Article 52 of the Act. You can think of it as the special rulebook, the dedicated process designed to identify and oversee these massive general-purpose AI models, or GPAIs, the ones with the potential to pose that systemic risk we're talking about. It's the legal machinery built specifically for this challenge.
Okay, so how does this whole process even get started? What's the tripwire? Well, it turns out there are two main ways this whole regulatory machine can get switched on.
On one side, you have what the Act calls high-impact capabilities. This is the really technical stuff. It's about the massive amount of computational power, measured in flops, that was used to train the model. Just think of it as the raw horsepower of the AI's engine. On the other side, a model can be flagged for its significant market impact. This has nothing to do with technical specs. It's all about its influence and reach, specifically how many business users it has. So you can get flagged for being incredibly powerful or for being incredibly widespread.
And once a model hits one of those thresholds, things move fast, really fast. The provider has just 2 weeks to notify the European Commission. That tight deadline tells you a lot about the urgency lawmakers feel about getting these powerful models on the regulatory radar as soon as possible. And here's where it gets really interesting, because the law is designed to be proactive. The notification is mandatory, even if the provider just knows their model will meet the threshold in the future. So, for example, before they even kick off a giant training run. The goal is to get ahead of the curve, to be anticipatory, not just reactive, once a model is already out in the wild.
So, a model gets flagged. What happens next? Well, this is where it enters a fascinating phase, a structured dialogue between the company and the regulator.
Here's how it works. After the provider notifies the commission, the model is legally presumed to pose a systemic risk. This is a crucial starting point, because it cleverly shifts the burden of proof. The responsibility is now on the provider, the folks who have all the information about the model, to present their counterarguments. And finally, the commission evaluates all the evidence to make a decision.
Now, the provider absolutely has a right to be heard. But, and this is a big but, the Act is clear. They can't just say our model is safe. They have to present sufficiently substantiated arguments. That means bringing concrete, objective evidence based on the model's design, its limitations, or the safeguards they've built in. The burden is entirely on them to build a compelling case.
All right, so arguments have been made, evidence is on the table. Who makes the final call? This is where the European Commission steps in as the ultimate decision maker.
The Commission holds the ultimate authority here. It can designate a model as having systemic risk based on that notification process, but it can also act ex officio, that's on its own initiative, if it spots a risky model that wasn't flagged. It can also be prompted to act by alerts from a new independent scientific panel of experts. But no matter what, any decision has to be grounded in a detailed set of criteria laid out in Annex 13 of the Act.
And here's a subtle but really critical detail. An earlier draft said the Commission shall adopt updates, which implies an obligation. They have to do it. The final text says it is empowered to adopt, which grants a discretionary power. This gives the Commission more flexibility to decide when and how to update the rules, allowing the law to adapt over time without being locked into constant mandatory changes.
So, what happens if the Commission decides a model does pose a systemic risk? Well, it's not just a private letter. This designation comes with significant and very public consequences.
First off, the model gets added to a public EU list for everyone to see. This then triggers a whole host of new obligations. We're talking much stricter rules on transparency and data governance, heightened regulatory scrutiny and ongoing monitoring, and they may have to follow tougher codes of practice. It's a brand new, much more demanding level of responsibility.
But this designation isn't necessarily forever. The law has a built-in review process. After 6 months, a provider can request a reassessment. But just like with their initial arguments, they have to come with objective, detailed, and new reasons that show the model's risk profile has actually changed for the better.
So let's zoom out. When you look at all of these steps, the triggers, the presumption, the decision, the consequences, a pretty clear philosophy starts to emerge. The goal isn't just regulation for the sake of regulation.
Ultimately, this entire Article 52 procedure is a massive balancing act. It's a framework that's been carefully designed to steer innovation in a responsible direction. It's not trying to stop the development of powerful AI, but it is trying to make sure that as these models are built and deployed, there are guardrails in place to protect society from systemic harm. And this brings us to the final big question. Is this meticulous, precautionary framework the key to unlocking the benefits of AI safely? Or does it risk becoming a bureaucratic barrier that slows down Europe's ability to compete and create the next great innovation? That's the debate that's going to shape the future of AI for years to come.